Mr. Chief Justice, and may it please the Court. My name is Patrick McKee, and I too represent the state of Texas, appellee. In my time before the Court, I will demonstrate the appellant did not receive ineffective assistance of counsel. Your Honor, this is a case about the typical scenario where the appellant finds the attorney that she wants to have, and then only after receiving a result she doesn't like, she fires her attorney and claims to have received ineffective assistance of counsel.
But counsel, wasn't he suspended from the practice of law at the time he represented her?
Yes, Your Honor, officially he was suspended at the time of representation. However, in Cantu v. State, this court flat out rejected a per se rule that suspended or disbarred attorneys at time of representation is a finding of ineffectiveness as a matter of law. Further, there are two reasons why this court should rule in favor of the state. Dan Herbster, first, was not ineffective as a matter of law, and second, Dan Herbster was not ineffective under the Strickland standard. To my first point, Dan Herbster was not ineffective as a matter of law. As we mentioned, in 1996, Cantu v. State, this court rejected a per se rule and instead looks at a case-by-case basis and finds ineffectiveness as a matter of law only when the performance reflects so poorly that incompetence can be inferred. And that's not the case that we have here, as we can see by the 7 factors laid out in Cantu v. State. Now, opposing counsel mentioned 2 factors we might mention in our favor, however, failed to mention any of the factors that would be in favor of Dixie Herbster or finding ineffectiveness as a matter of law. And that's because the majority of factors are, in fact, in favor of not finding ineffectiveness as a matter of law. Turning to the first factor, the severity of the sanction. And here, Cantu court put lawyers in 2 categories. Were they suspended or were they disbarred at the time of representation? And in Cantu v. State, they placed great weight on the fact that the attorney was merely suspended at the time of representation as opposed to being disbarred. Similarly, in this case, Dan Herbster was not disbarred, but was merely suspended from the practice. This factor then weighs in favor of the state. Another factor weighing in favor of the state is the third factor in that test, which is this an isolated incident or was this a pattern of misconduct? The Chief Disciplinary Counsel on page 8 of the record, the Texas State Bar mentioned that this was, quote, an isolated incident, and that was why it was a suspension rather than a disbarment. This factor also weighs in favor of Dan Herbster. Now, turning to a third factor that weighs in favor of the state, that is that we look to the similarity between the type of proceeding that resulted in suspension versus the type of proceeding in the underlying case. The type of proceeding that resulted in suspension in Willie Redbeard's trial was a manslaughter case. It was a felony case. This is a simple DWI case, a misdemeanor.
And it was an intoxication manslaughter, right?
It was, Your Honor. However, the difference between misdemeanor and felony and the distinction there is important, as noted by the Chief Disciplinary Counsel on page 8.
I mean, the difference is there wasn't, for instance, here a pedestrian standing in that ditch when she drove into it. If there had been, then this would be an intoxication manslaughter case, wouldn't it?
Potentially, Your Honor, but that's not what we have here. And you can see just in the practice of law, the way the prosecutor's office treats the difference between a felony and a misdemeanor. It takes a prosecutor a long time to get into a felony court. They always start out in the misdemeanor courts. And the Chief Disciplinary Counsel of Texas State Bar supported this distinction between misdemeanors and felonies by stating that one of the reasons Dan Herbster was reprimanded is because he took on a, quote, felony case for which he had no previous experience. So this is another factor that weighs in favor of the state.
Do you have any experience in misdemeanor cases?
Your Honor, it's unclear whether he has experience in misdemeanor cases, but a criminal attorney would have to start somewhere, and just because you don't have any experience in a particular case does not make you ineffective, as stated by the Fifth Circuit.
Well, it's the same procedures and the same substantive law. It's just basically whether or not the sentence is going to be longer than a year that distinguishes between a misdemeanor and a felony, and how many jurors you get on your jury, right?
Well, Your Honor, no, there are other differences going into consideration of who you're going to have on the jury and the distinguishment between the level of punishment alone would change the trial strategy that you would have going into either a felony case or a misdemeanor case.
Well, also, I think the record's clear that he had not handled any other criminal cases before this one that he got suspended for, so obviously he hadn't handled any misdemeanors either. But regardless, he's a civil lawyer, is my understanding of the record, and he got in trouble on the first, the one time he handled a criminal case, he got suspended for it, and now he turns around and represents someone while he's suspended in another criminal case. Isn't that obvious that he disregarded the sanctions he got from the CDC and just went ahead and recklessly took on another criminal case without knowing what he was doing?
No, Your Honor. Again, as the Fifth Circuit stated in 1986 in U.S. v. Lewis, just because you're inexperienced in a particular field does not mean you're ineffective as it relates to either the Strickland standard or being ineffective as a matter of law. And again, the Chief Disciplinary Counsel found a distinction between taking on a felony case when you have no previous experience and taking on a misdemeanor case, as was this particular case. A fourth factor out of the seven-factor test weighing in favor of the state is the seventh factor: the nature and extent of the attorney's professional experience and reputation in the community. The Chief Disciplinary Counsel on page 8 of the record stated that, quote, he has a very positive reputation in the Luna County community and also has won several jury trials. This factor also weighs in favor of the state. Dixie Herbster herself stated on page 6 of the record that Dan Herbster was, quote, the best trial attorney in Luna County. This factor weighs in heavily in favor of the state and is just another reason why Dan Herbster was not ineffective as a matter of law.
Doesn't his own testimony, though, indicate almost a confession that he was incompetent to handle this kind of case, and the only reason he took it was he needed the money?
No, Your Honor. His own testimony, as stated on page 7 of the record, is a simple DWI case would have been much different than the previous Willie Redbeard trial. So that is precisely what Dixie Herbster's case was, a simple DWI case. But not only does the seven-factor test weigh in favor of Dan Herbster, also Texas case law weighs in favor of not finding ineffectiveness as a matter of law. As opposing counsel correctly stated, there are 0 Texas cases cited below finding incompetence as a matter of law, while there are 4 cited directly in the 15th District Court's opinion finding that there was not ineffectiveness as a matter of law. Cantu v. State, Hudson v. State, Sarabia v. State, and Smith v. State. Thus, Dan Herbster should not be found incompetent as a matter of law. To my second point, Dan Herbster was not ineffective under the Strickland test. Now, opposing counsel incorrectly stated that the burden was on Dan Herbster to meet the Strickland test, or somehow prove that he met the Strickland standard test. The burden of proof in this case is on Dixie Herbster to prove both prongs of the Strickland test. She must prove that his performance was objectively unreasonable, and she must prove that but for that performance, the result would have been different. Now, this is a hard burden of proof to meet, on top of the fact that there is a standard of review in this case of abuse of discretion. This court will not overturn a trial court's finding unless, in an abuse of discretion standard, unless it was unreasonable or arbitrary. Further, all evidence must be viewed in light most favorable to the trial court's findings, and reasonable inferences being taken against Dixie Herbster in this case. Now, not only is there this burden of proof and this high standard of review, but there's also strong presumptions in the state of Texas that the trial counsel's actions were appropriate or strategic decisions. As this court noted in Thompson v. State, there is a strong presumption, and we must presume that counsel's conduct fell within the wide range of acceptable behavior at trial. And a second presumption, as stated in Ex parte Ellis in 2007 by this court, is that we must presume that the challenge action could in fact be sound trial strategy.
Is there any sound trial strategy for just taking an adverse expert's word for it that a test like the Kane assessment is a good test?
Your Honor, that may not have a legitimate trial strategy, but that is not what happened in this case. Dan Herbster did not merely rely on the word of Dr. Appleby. As stated on page 29 of the record, he also talked with a psychiatrist from Houston. As stated on page 32 of the record, he talked with criminal defense attorneys in Luna County. None of these individuals had anything negative to say about the test. And on page 33 of the record, he went to the medical library in South Texas and read an independent study. That independent study also did not have any negative findings regarding the Kane assessment test. But looking then to the first prong of objective unreasonableness of Dan Herbster's behavior and what Dixie Herbster must prove. Now, this case is similar to the McFarland v. State case that this court decided in 1996, finding that that attorney was not ineffective under the Strickland standard. In that case, the defendant had 12 points of error alleging ineffective assistance of counsel, ranging from deficient cross-examinations to inadequate investigations, much like the present case. However, in that case, the court noted that each one of these points of error were merely sound trial strategy or trial tactics, and that this court, as stated in Thompson v. State, would not second-guess those sound trial strategies. Now, turning to the 3 points of error that Dixie Herbster brought up related to Dan Herbster's performance.
Hold on. Your argument is that, on the confrontation clause, is that all this should go to the weight of the evidence, not its admissibility. How can it then be sound trial strategy not to call the analyst who, as y'all have put it, just wrote down the results of the test, who had some apparent issues that might render her credibility in question and impress the jury that the test is not reliable? How can that be sound trial strategy not to call?
Dan Herbster, Your Honor, tells us how that cannot be, or how there's a different trial strategy that he had in mind. And that was on page 36 of the record when he talked to criminal law practitioners in Luna County. And they stated that Brittany Lindsay, they were familiar with her, she was rock solid, and that if she took the stand, it would be a slam dunk for the other side. Well, Dan Herbster certainly didn't want to see a slam dunk case for the other side, so he took the strategy upon himself to address those issues in Clint Harbor's cross-examination. And again, as this court stated, it will not second-guess sound trial strategies by trial counsel. Turning to the next point of error raised by Dixie Herbster, and that's the cross-examination issue of Dr. Appleby. Again, this is sound trial strategy by Dan Herbster. He states as much on page 35 of the record that Dr. Appleby came across as pompous and arrogant on direct examination. Further, the court on page 21 noted that the jury was in fact falling asleep during this testimony. He saw all of these indications while he was front and center at trial and made a reasonable trial decision not to prolong a cross-examination and allow him to rehabilitate himself. That, again, is a sound trial strategy. Moving on to the third issue, which is the investigation issue of the Kane assessment test. We've gone through all the different things that Dan Herbster did, talking to a psychiatrist, reading an independent study, talking to practitioners. He made a reasonable decision at that point to discontinue his investigation. And under Strickland v. Washington in 1984, Supreme Court stated that is acceptable. If you make a reasonable decision to cut off your investigation, that is acceptable if it's reasonable to do so. And in the Supreme Court in Wiggins v. Smith stated in 2003 that we apply a heavy measure of deference when a trial attorney decides to cut off their investigation at that point. Thus, Dan Herbster should be afforded a heavy measure of deference in his decision to cut off that investigation. Now, even if you found that his conduct was unreasonable, Dixie Herbster still fails on the second prong of the Strickland test, which is that it must have caused her prejudice. She complains of Dr. Appleby's cross-examination in this Kane assessment test. However, the findings of the trial court on page 41 is that the jury did not place any weight on any of that evidence. The jury believed the probation officer, who testified on page 26 of the record, that Dixie Herbster would not stop drinking unless she was given jail time. For these reasons, the state of Texas respectfully requests this court affirm the decision of the 15th District Court. Thank you.